Good morning, children. Children, today we are going to start the new lesson, Judiciary, Union Government, Chapter 20. We already discussed about the two organs, legislature and executive. The third organ is judiciary. Legislature who make laws, executives is those who enforce or execute laws, and judiciary is the third organ which is working in an independent and impartial manner. It not only resolve or solve disputes but also is the final interpreter of the constitution. If somebody does not work according to the provisions of the constitution, it is the judiciary who checks this. So whenever a dispute arises regarding property or violation of rights or any other exploitation violence, then one can move to the court to get justice. The court gives justice to the aggrieved party. Therefore, a system of courts under independent judiciary is the foundation of democracy. System of courts. There are different levels of courts we will study in the coming lesson. Independence of judiciary. Justice is possible only if judiciary is independent, impartial, and unbiased, obviously. And it is absolutely correct that justice can only be possible if it is working in an independent manner. Once it becomes biased, once it is not working in independent manner, it cannot provide justice to all. So that's why we all have faith in justice and also in the judiciary. The judiciary not only protect the rights of the citizens but also resolve various disputes arising out of civil cases, criminal cases, and constitutional matters without any pressure from the executive or legislature. This judiciary is totally separated from the other two organs, that is executive and legislature, and it not only solve the disputes but it is also helping in the smooth working of government and especially in a constitutional way. It always protects the constitution, and if there is any issue regarding constitutional matters, it solves those problems. Our constitution has various provisions which make our judiciary independent and keeps it free from the influence of legislature and executive. How we can say that it is really working in an independent and it is an impartial manner? There are three special provisions of independence of judiciary. The first point is that the judges are appointed on the basis of their qualification. They are not appointed like your Lok Sabha members or Raj Sabha members. They are appointed on the basis of certain qualification. They cannot be removed easily. Impeachment is the process to remove them, like president. Judges are paid adequate salary. Their salary and allowances cannot be reduced during their tenure. The tenure of the judges is fixed. So these are some of the special provisions which proves that judiciary is working in an independent and impartial manner. Now there are two types of cases, civil cases and criminal cases. Civil cases are those like problems related to property, marriage, money, rent, etc. They also include the infringement or violation of rights of individual. If somebody rights have been violated or somebody has been exploited, that also comes under civil cases. Criminal cases are like robberies, murders, kidnapping, violence, cheating, harassing of women. These are some of the examples of criminal cases, and always the criminal cases starts with logging with FIR, first information report. After the investigation by the police, the case is filed in the court. So first of all, in criminal cases, it is first logged by FIR, first information report. In case the crime is proved, the accused can either be sent to jail or fined, or in some cases both fined and jailed. An FIR is lodged with the police about a criminal offense. According to the law, wherever a person informs the police about an offense, it is compulsory for the police to register an FIR. Without FIR, the case will not be forwarded in the court. Case cannot be filed in the court, you can see. So the notable point here is that if anyone who knows about the offense can file an FIR and not necessarily the victim of the crime. The point is that anyone who knows about the offense can file an FIR and not necessarily the victim of the crime. It is not that if it happens with anyone, that person will only. If anybody is knowing, one can also file an FIR. Single, unified and integrated judicial system. Single, unified and integrated judicial system. You have to understand these terms. It is very important. Single, unified and integrated. Integrated is like a chain जिसकी कड़ियां जुड़ी होती हैं. It is working like a chain, integrated one, and it is working in a unified manner. If the case is forwarded from lower court to upper court, higher court, Supreme Court, like this, this judicial hierarchy is working in an integrated one. And Supreme Court, as it is the highest, it is the apex judicial authority, that's why it's the single one, followed by High Court in the states and then the subordinate courts in every district. The lower court in the judicial hierarchy order is the Court of Magistrate. Please underline it, children. This is very important for you. You can get a question from here. The lower courts are controlled and supervised by high courts. A judgment given by lower court can be challenged in the high court. If one is not satisfied with the decision of lower court, one can move to the upper court. And ultimately, one can move to the Supreme Court, not more than that. The Constitution of India says that the law declared by the Supreme Court shall be binding on all courts within the territory of India. Yes, whatever the decision will be given by the Supreme Court, that will be binding on all the courts, whether it is a high court or subordinate courts. Let us study this Indian judicial system. This is very important. Supreme Court, below is High Court, and then is lower subordinate courts or lower courts in district. Now from here, it is divided into two parts, civil and criminal cases. Civil cases are handled in civil courts. Criminal cases are there in criminal courts. These are the layers of district judge, then civil judge of first class, and then is your sub judge second class. Here in criminal courts, additional session judge, assistant session judge, below it metropolitan magistrate or civil judicial chief judicial magistrate, and below it is court of magistrate of second class. These are the levels of judges which is working one after the other. It is assisting it, you can see. And then is the court of magistrate of second class. Supreme Court. Now let's study when it was established, what are its composition, and what are the qualifications to become the judge of Supreme Court. First of all, it was established on 26 January 1950, and its headquarters is at New Delhi. is the highest court of the country. Then is the Supreme Court comprises of Chief Justice and a maximum number of 31 judges who are appointed by the President of India on the recommendation of the collegial system. Now, who are this group of members under this collegial system? It is a close group consisting of Chief Justice of India and 4 senior judges of the Supreme Court. Because all the members of this collegial system, they advises the president, they recommend the president actually that who is going to become the Chief Justice of Supreme Court. While appointing the Chief Justice, the president consults other judges as she or he deems to as she or he deems to so the president consults other judges as he or she deems proper. Normally, the senior most judge of the Supreme Court is appointed as the Chief Justice of India, and the other judges of the Supreme Court are also appointed by the President of India. If we talk about the qualifications of the judges, one must be an Indian citizen, and second, a judge of High Court or other courts for a minimum period of 5 years, and a distinguished jurist in the opinion of the President of India. Distinguished jurist means a judge with having a special quality or special work done by him, and that work makes a person a distinguished one from the other, and especially in the eyes of the President of India. If we talk about the tenure and removal from office, the Chief Justice and the other judges remain in office till the age of 65 years. And only under certain circumstances a judge can be removed from the office. And what is that special circumstance? If he or she is proved as misbehavior on the grounds of misbehavior or incapable of discharging his duty. In that case, a resolution has to be passed by each house of the parliament by a special majority during the same session, and this process is called a impeachment, and in that case will be removed by the president. If we talk about salary and allowances, a Chief Justice of India has 2.8 lakhs per month. Other judges have 2.5 lakhs per month. Beside that, number of allowances are there. Free residence is there. Car, travel allowance, leaves, pensions on retirement is also given to them. Now, the next topic is power and functions of Supreme Court, which is very, very important for you. The first function is original jurisdiction. Children, please go through that word, original jurisdiction. Original means which originates in Supreme Court. For the first time, it is originating in the Supreme Court. That is original jurisdiction. Now, what sort of disputes will come here? Disputes like between the union and states, between two or more states, or between union and states, vice versa, and one or more states. Interstates disputes like your water sharing disputes, power also come under this category. Next is your appellate jurisdiction. Appellate jurisdiction means in this case, it here appeals against the decision given by High Court or other courts regarding constitutional matters or civil or criminal cases. This jurisdiction is applicable to cases involving interpretation of the Constitution, cases sent by High Court, and the criminal cases. Interpretation of the Constitution, if somebody has not worked according to the provisions of the Constitution, or any matter is related regarding the provisions, in that case, all these cases will come under the Supreme Court and it will come under appellate jurisdiction. So, this jurisdiction is applicable to cases involving interpretation of the Constitution, cases sent by High Court, and the criminal cases. Regarding one more case also comes under this appellate jurisdiction. If a High Court changes that somebody has appealed from lower to High Court because one is not satisfied with the decision given by lower court, and in the next case High Court changes the decision of lower court and gives a death sentence, in that case also this case will be sent to the Supreme Court. This will also come under appellate jurisdiction. Means if it is not, somebody is not satisfied with the lower court, one can appeal to High Court, and again if is not satisfied with High Court, one can appeal to the highest court, apex court, that is Supreme Court. And in that case, Supreme Court will review its own decisions taken earlier. In appellate jurisdiction, sometimes the Supreme Court also review its own decision. The decision which is given by Supreme Court themselves reviews its decision, changes its decision. Okay. Next is advisory jurisdiction. Advisory jurisdiction covers constitutional issues or matters of public importance. If the President of India desires to obtain the opinion of Supreme Court, in any such opinion given by Supreme Court is not binding on the President. Is regarding the constitutional matters or regarding the public importance, if the President is been interested to take the decision from the Supreme Court, then it can take advice, but that advice is not binding on the President, that it is not been binding to the President that it will follow the decision given by Supreme Court. It can only take the advice. That's why it is called advisory jurisdiction. Children, these are some of the powers and functions. After seeing the video, children, when I will take the meeting, then there will be a two-way interaction, and then there I will discuss some of the cases which comes under original jurisdiction. I'll give you some certain examples there. Appellate jurisdiction, like this, regarding all the powers and functions, I will discuss some of the examples in the meeting when there will be a discussion with you. Next is supervisory jurisdiction. It gives power to the Supreme Court to supervise the functions of all the courts below it. As I told you that our judicial system is an integrated one. It is working like a chain. If we are not satisfied with lower courts, we will appeal to high, and after High Court we can go to the last, that is Supreme Court. So here Supreme Court is working like a supervisor. It supervises the functions of all the courts below it. That's why it is called supervisory functions. Next is court of record. Court of record means whatever proceedings takes place in the court, that is been reserved. That means that if any decision has been given on any case, if any case has been closed, all those records are kept in the court. That's why it is called court of record. These records can be cited as precedents in future in all the courts. Now the question arises, why we will keep all these records? These records are being kept so that it can be set as an examples, or it can be seen, it can be taken as a help in future in other cases related to it, or any other case similar to it. We can take such examples or such help from the previous decision in any case. These records can be cited as precedents in future in all the courts in the country. Precedent means, in future means, whatever has been taken place before, it can be set as an example. Protector of fundamental rights. Protector of fundamental rights. Yes, our Supreme Court is guiding our fundamental rights, protecting our fundamental rights from any type of violation or exploitation done by anyone. That's why it serves a role of protector. Of what? Of fundamental rights. Because Supreme Court can declare a law passed by the legislature null and void if it encroaches upon the fundamental rights of the people. If it any way, the laws which has been made by the legislature, because we all know that legislature and executive are interdependent. So if any law has been made by the legislature and it is hampering the fundamental rights of the people, there the Supreme Court will declare that law null and void. It will declare invalid. It will interfere in that matter for the protection of the fundamental rights of people. Therefore, our fundamental rights are secured in the hands of Supreme Court. Yes, it's really 100% true that our fundamental rights are secured in the hands of Supreme Court. So Supreme Court is there to protect our fundamental rights if any type of violation takes place against anyone, against any person. So children, please go through the video, and in my next class we will continue the two remaining powers and functions of Supreme Court, that is guardian of our constitution and power of judicial review. What do you mean by judicial review? So children, please go through this. This is very, very important for you. Please go through the terms very carefully. Thank you, children.